Good evening or good morning, everyone. This is the September 26th edition of the Tesoro broadcast. Last week we talked about Richard Sanders and the letter that he wrote to the judge. This week we're going to go over the order that was issued by the judge, and it starts off this way. Before the court is defendant's renewed motion for pretrial release upon conditions pursuant to 18 U.S.C. section 3142 and request for hearing. 1. The background. On January 25, 2010, an indictment charged defendant Richard Bruce Sanders with felon in possession of a firearm and felon in possession of ammunition. Sanders was arrested on February 1, 2010, and his initial appearance occurred on the same day. At the same time, Sanders waived his right to a detention hearing, reserving his right to a detention hearing at a later date. He was remanded to the custody of the United States Marshals. On March 24, 2010, Sanders moved for a detention hearing, and the hearing was conducted on March 26, 2010. United States Probation Officer Sean Lyle recommended detention. Witnesses at the hearing included Task Force Officer Steve Feuerstein and Musselshell County Deputy Sheriff Sean Lesnick. The parties agreed that the United States had the burden of proof, without benefit of any presumption of detention. At the conclusion of the hearing, the magistrate ordered Sanders detained. The magistrate explained that the factors considered under the Bail Reform Act, 18 U.S.C. sections 3142 et sec. Included 1. The nature and circumstances of the offense, including specifically that it involved firearms, and it was not his first offense. 2. Sanders' criminal history record reflect 4 prior felony convictions. 3. The weight of the evidence on the current charge. And 4. Serious concerns by law enforcement officers regarding danger to the community and persons in the community. The magistrate ordered Sanders detained by detention order filed on March 26, 2010. Trial on the charges was initially set for March 29, 2010. Trial has been continued 4 times as motions by Sanders. Trial is currently scheduled for October 4, 2010. On July 22, 2010, the magistrate received a letter from Sanders in which he raised concerns about his continued detention. The court directed the clerk of the court to send copies of this letter to counsel of record. On July 28, Sanders' counsel filed the pending renewed motion for pretrial release and request for hearing. Standard of review. The court reviews a magistrate judge's decision with respect to pretrial detention on a de novo rather than a differential standard. See U.S. v. Cohen, 912 F2D 1190 at 1192 and 1193, 9th Circuit, 1990. Additionally, the district court is not required to hold an evidentiary hearing with no evidence is offered that was not before the magistrate. Analysis. In support of his appeal of the magistrate's decision, defendant argues that he must be able to manage his residential units in order to finance his defense. Further, defendant argues that his statements to law enforcement did not amount to a risk of harm sufficient to require pretrial confinement. After a thorough review of the lengthy detention hearing held before Magistrate Judge Otsby, the court finds that she adequately considered and explained the factors under the Bail Reform Act. Specifically, Magistrate Judge Otsby found, and the record supports, that the testimony from the detention hearing established by clear and convincing evidence that defendant poses a serious threat of danger to the safety of other persons and to the community. Evidence presented at the detention hearing shows that the defendant threatened the life of law enforcement officer involved with the investigation leading to defendant's arrest. Testimony revealed defendant stated desire to put a bullet in the law enforcement officer's head. and stating to the officer, "I know where you live, mother F blank 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 R." His criminal history also includes offenses involving violence. The current charges involved alleged illegal possession of multiple firearms. His criminal history also reveals a propensity for failure to adequately comply with conditions imposed upon him by courts and probation. Sanders argued that his statements reflect expressions of feelings rather than intent to commit violent acts, especially when considered with his history of firearms as unavailing. Sanders failed to present any compelling new or additional evidence which would warrant a second detention hearing. For the reasons set forth above, another de novo review, this court finds that pretrial detention was and continues to be appropriate in this case, and Sanders' renewed motion for pretrial release upon conditions pursuant to 18 U.S.C. section 3142 and request for hearing is hereby denied. Dated this 10th day of September 2010, Jack D. Shandstrom, Senior U.S. District Judge. As it can be seen, the judge does not feel that Sanders would be somebody that could be released back into the public. And for a good thing. I mean, he was tampering with witnesses, he was doing all sorts of things. But this is typical, and this guy is a friend of Gordon Sanders. And Gordon Sanders, in emails, had Richard Sanders threaten me, and we put all these threats on a DVD and sent them to the U.S. attorney and sent them to the sheriff in Muleshoe, where the court is, to the district attorney and to the sheriff. So there was some concern there that he could show up on my doorstep, or somebody from his Freeman group could show up on my doorstep and threaten to proceed to do me some sort of physical harm. But I'm glad he's in custody, and I hope this time around that he does go to trial on the 4th of October, because I really would like to see what kind of a sentence that he would get. Now the only thing has to be is that the Attorney General for the state of New Mexico should go after Gordon Walters for ripping people off for over $1 million. You know, this last time around, the state of Montana has a $1.3 million judgment on him, and it seems that Gordon is going around and bragging that he can't be touched, that he's free of prosecution, that he cannot be nailed for prosecution of stealing money from people and not returning what he says he's going to be returning as far as their investment returns are concerned. He thinks because he believes that he's sovereign that he is immune from prosecution. Well, I don't believe that, and it doesn't make any difference. If he committed a wrong, he should be arrested and he should be charged, and his property should be confiscated, because he does own the house that he's in, and we have the records to prove that. Thank you very much. We will do this again next week on a new subject. Thank you. Bye.